Okay, medical examiner on the stand. Cause of death is not at issue here. Everybody knows that she was strangled to death. The defendant admitted it. He says he did it sort of by accident in this drunken fight. Let's bring in Jeffrey Wolf. He's a criminal defense attorney in Denver, Colorado. For both sides, a medical examiner, even in a case where there's no how did this happen, it can do a lot of, it can bring the victim back into the courtroom. It can, especially if there are photos, oh, there's a dead person. It brings a sense of reality to jurors. This was very clinical, the back and forth here, and one of the defense characterizations is that they were both drunk and they've been drinking these martinis. She's at a .09. Give me your assessment of how this witness either helps, hurts either side.
Well, I mean, medical examiners, in my experience, cut both ways, right? Because, like you said, they bring the victim into the courtroom, essentially. They paint the picture of the deceased in a way that can't be done really any other way. There are autopsy photos that typically come in and they describe the injuries that the person suffered. And a lot of times they do what we just saw them do, which is to minimize the bad facts about the deceased. .096, right? You can hear that in any trial that involves intoxication when it is a defendant as drunk. It is legally drunk. If you get a DUI, you have a vehicular homicide case, the prosecutor and anyone else from a forensic perspective are going to pound their fist on the table about how that person is legally, per se, drunk. But what did the medical examiner do there? She said, well, it really depends on how it affects an individual person. If you drink a little bit more, that might not affect you as much. So she softened the blow there for the deceased, for the victim in this case, in a way that she would not have done it if it had been the BAC of the defendant in a case. And so, again, they cut both ways depending on who they're working for and who they're coming in to testify about. And if I am the defense attorney in this case, I am going to absolutely hammer that bias.
Yeah, that's a good point. Yeah, because she went out of her way as the medical examiner to educate the jury on, well, to your point, maybe she wasn't drunk at all, because if she was used to drinking at a .09, and does it metabolize afterwards at all? I mean, is that .089 when you die? Is that it? Or does your body bring it down a little bit? We'll see if the defense tries to explore that on cross-examination. We'll get a break here, but before we do, a little breaking news to pass along to you. All right, that's Karen Reed talking to our Matt Johnson. Let's talk a little bit about this process of jury selection day 2. Jeffrey Wolf still with us. A ruling this morning from the judge allowing the Commonwealth to bring in a crime scene reconstructionist for Karen Reed to testify. You remember, maybe you do, maybe you don't, their reconstructionist in the first round was this Joe Paul, this Trooper Paul, pretty green, pretty basic, got annihilated, one could argue, on cross-examination, comparing him to the defense reconstructionist team, which was hired by the federal government. It wasn't even a fair fight. Now they'll have their own expert come in, and this time around the defense will have to disclose that, yes, they did compensate the other reconstructionists that did such a great job the first time around, partly because they appeared to be unbiased. Big picture, same set of facts, different attorneys, different jury. Why should any side think there's going to be a different outcome?
Well, the reason that retrials are so different and the reason that there could be a different outcome here is because both sides have seen what the other's best pitch was, essentially. And it allows everyone to retool and come back and bring in new strategies. And quite frankly, this judge is ruling differently about what evidence is going to come in because now she has seen what the attorneys have done with her initial rulings, and she doesn't really like what they've done with her initial rulings. And so she's retooled what she's going to allow the attorneys to do the second go around. She's kicked one attorney off the case, which was, quite frankly, one of the more passionate advocates in the case in Mr. Jackson. And now they're moving forward with completely different legal teams, with completely.
Well, Jackson's still on the case. She didn't bounce him.
Okay, I'm sorry.
No worries. There was a talk that he might be because of the representation to the court about the crime scene experts. But no, he is very much still in the case. In fact, we've learned that he will be doing the openings.
Okay.
What do you?
But the intros. That was my mistake.
No worries. There are a lot of moving parts in this one. Victoria George, the new attorney brought in by the defense, who was a juror the first time around. She has her law degree, just graduated law school. She's sitting as a juror. Now she's sitting at the defense table. What kind of insight will that individual, Victoria George, give the defense team, if any? Or is this, hey, she wants to join, let her join, she's volunteering?
I think it's incredibly invaluable for the defense, quite frankly, because what I have found anytime I talk to a jury after a trial is that there are all of these things that the prosecutor and myself have talked about during the case, on the things that we are focused on and the things that we are arguing about in a case, whether it's behind the scenes or whether it's at a motions hearing prior to a case starting. And then we go and talk to the jury afterwards, and they are looking at something completely different that none of the attorneys or the judge have focused on. And what this juror is able to do is to give insight into what the jury was actually thinking, because I think it's well known that jurors actually do talk during breaks, and even though they're instructed by the judge to never discuss the case, quote unquote, I think everybody knows that they do. And so this juror is able to give that invaluable insight to the defense team. And quite frankly, I'm a little surprised at how often judges will allow this to occur in cases, because we know this isn't the first time that this has occurred, because now the defense is basically got a window into the way the jury thought about the evidence the first time around, and I think it's going to be invaluable to the defense team.
Yeah, it is a unique situation that she's in. There's also, for Karen Reed's supporters, they're not happy because the court has implemented a larger zone around the courthouse. So we're not going to have that whole free Karen Reed noise coming inside the walls of the courthouse because they've been pushed back by a couple blocks. Well, you probably still hear
they just sued
Turtle Boys there. Oh yeah, we'll see. Maybe it changes. Right. They are fighting that vehemently. All right, lots to talk. We talk about Karen Reed for hours and hours and hours, but we're going to get a break, and we're going to switch gears to Michigan because there is some unique evidence coming in to the Linda Sturmer case right now. We want to get up there and show it to you. A witness on the stand showing images of that minivan, the family car that Linda allegedly used to intentionally hit her husband with and kill him after she tried to burn him, and it didn't work. Stay with us.